matter to come before us this morning is Frith versus Frith. Both sides have 15 minutes to argue. However, the appellant is the only side that's filed a brief. So you have 15 minutes with which to do with as you please for our argument. We have read the briefs and we're ready to see who you are.
Thank you very much, Your Honor. May it please the court, my name is Carol Horvath, and I'm here today representing the appellant, Roy Frith. The issues that I would wish to argue before the court are three. Whether or not the evidence presented at the hearing is sufficient to establish minimum contacts for personal jurisdiction. Whether or not my client was denied due process because he was in a situation where he was appearing telephonically. He couldn't really hear what was being said and wasn't really able to ask the questions that he needed to ask because he couldn't hear the testimony. And then lastly, whether or not the trial court's decision is against the manifest way of the evidence. And I'll endeavor to be very brief. This involves a hearing before a magistrate with two pro se litigants. And it appears that Mrs. Frith had moved up to the Summit County area sometime in October of 2015. This matter came before the court in July of 2016, I believe, based on her petition where she was asking for a civil protection order. Felt that she was threatened and alleged that domestic violence had occurred. My client probably had not been to Summit County for about 17 years, was a resident of Florence, Kentucky, and probably has not been to Ohio, I would estimate, although it's not in the transcript, for about 12 years. So she had moved and had a number of months where she was living in Ohio. He did not follow her. She was complaining about some threatening emails. His testimony was that he was attempting to contact her to deal with some issues that were still back in Kentucky. In other words, they had a condominium and a pending foreclosure. There were issues of joint bankruptcy versus him, I guess, filing on his own or allowing the home to be foreclosed upon.
Excuse me, are the emails part of the record?
Well, from the transcript, they do not appear that they are, Your Honor. It doesn't appear that anyone ever moved that they be admitted into evidence. There's also a Federal Express, some sort of correspondence that was testified to, but it doesn't appear that there ever was any sort of introduction into the record of the emails. Now, I would note that at some point in time that the appellee had asked if she could submit them. And so she may have conveyed them to the court. I did not enter any objection to that fact because I felt that the important time for the emails to be submitted would have been during the hearing and not post-hearing, mainly because my client wouldn't have the ability to ask any questions about the emails or know what was threatening about them. So I can't honestly characterize emails in any fashion because I don't know what they said from the transcript, and my understanding when I called the court reporter, she told me at the time I called her prior to filing my brief that they were not
Were they read into the record by the magistrate?
No, Your Honor, they were not. Basically, the appellee testified that he sent what she considered to be threatening emails, but she didn't specifically state what was so threatening about them. And she did testify about prior conduct that would have occurred before her move, obviously, to Ohio. But I think the real determining factor is what conduct was she complaining about at the time that was threatening. So based on the fact that my client really didn't know what was in the emails, and it appears that they were not admitted into the record, my argument would be that it was never established that there was any sort of minimum contacts for him to be able to be subject to any sort of personal jurisdiction with the state of Ohio. case of Freyberg versus Cuyahoga County Court of Common Pleas indicates that there has to be a notion of fair play and substantial justice for this type of matter to go forward. It's civil in nature, and obviously personal jurisdiction can be triggered. However, I would argue that there has to be sufficient evidence that establishes that whatever the emails were in fact threatening.
Is this argument waived by his appearance and participation in the hearing?
Your Honor, I think the court, irregardless, would still have to establish personal jurisdiction. I don't think simply by appearing, especially by a pro se litigant, that he could waive that argument. And I would...
How about a waiver as it relates to not objecting to the magistrate's decision? We can't tell from what's attached to the brief, I'm sure it's in the record, what the entire order of protection looks like. We just kind of have a strange uploaded copy of 2 pages. So I'm assuming there was no objection to the magistrate's decision made to the trial judge after this order was entered.
Your Honor, I believe that there was an objection.
There was?
I believe so. I don't want to misspeak, and if the court will allow me a few moments at the end.
That's okay, counsel. Ordinarily we could tell, but just in this instance, we can't tell right now, but we could find it. Thank you.
Okay, yeah, I don't want to misspeak to the court, but again, he's an out-of-state pro se litigant, and certainly he's supposed to be charged with the same knowledge an attorney would have. But the reality is that that's often not the case. People don't always know, and it seems that this is something that is a trend that more and more people in either domestic relations or juvenile court are appearing without an attorney, which I would imagine is a trend that would continue. It certainly is disadvantageous to him, but for whatever reason, he felt that it would be okay if he did appear telephonically, and clearly that didn't work out at all for him, because he really was unable to adequately hear some of the questions that were asked, and I think that impacted on his ability to ask any questions or be able to present evidence on his own behalf. Certainly the civil domestic violence hearing would be considered to be a full hearing, and he would be able to exert whatever rights he would have constitutionally. But my argument would be that based on the fact that he really couldn't hear much of anything, and the magistrate was aware of it but didn't offer any other options to him, that he really didn't have his due process rights. And lastly, I would argue that the decision is against the manifest weight of the evidence, mainly because there doesn't seem to be any evidence that was put into the record as to exactly what these emails said and exactly why they were threatening. And my argument would be that there needs to be some sufficient credible evidence to support the court's finding that my client did engage in or threaten some sort of domestic violence. The appellee in the trial transcript did state that she was not in fear of any future violence, but she was in fear because, and I'm quoting, "He's never let me say no before, and I really don't know what his mindset is." And my argument, Your Honors, would be that that shouldn't be sufficient for the granting of a civil protection order, that there should be some sort of quantified threat that is reasonable and credible and is not merely subjective. So for these reasons, I would ask the court to reverse the trial court's decision, or in the alternative, to remand it so we can at least know what the threats were and be able to present some sort of evidence on Mr. Frist's behalf as to why whatever was contained in the emails didn't meet the appropriate standard for the domestic violence. And with that out of the way, argue. And under those circumstances, I feel that it would be best to be brief. Court has, before it, appellant's argument. And I thank the court for your consideration, allowing me to come and present Mr. Fritz's case.
Thank you, counsel. Court will take the matter under advisement. We will issue a written decision, which we mail to both sides as well as post on the Ohio Supreme Court website. We are adjourned briefly until